That was a very interesting talk. I think in the UK, we're always looking to copy the US example, and that applies on both sides of the litigation debate. So both to the government, which is always, over the last 20 years certainly, has been looking to decrease entitlement to social security. Many of those ideas have been taken from the US. But also, on the campaigning side, the Child Poverty Action Group, of which I'm the legal officer, celebrates its 50th anniversary today, this year, and has had a test case strategy since the 60s, which developed really out of the US example. Some of the cases that Ken was talking about there, trying to establish the right to social security. So it's very interesting to compare notes on that. I'm not going to talk about the last 50 years or even the last 20 years. I'm going to focus my talk just on the last 5 years. And I hope that's justified, not just because that's where most of my experience lies, or just because we're all quite keen to get to lunch, but also because the last 5 years have seen a significant increase in the intensity of welfare reform and the harshness of both the treatment and the public portrayal of people who are on benefit. And as a consequence, in the last 5 years, in the last year, food bank use had increased to 900,000 people went to food banks in the last year. And half of those, when they were surveyed, said that they went because of benefit changes or because of benefit delays. I'm going to focus on 3 main welfare reforms. That's the work programme, the bedroom tax, or variously also known as the removal of the spare room subsidy by the government, and the benefit cap, and look at some of the quite complex and tortuous litigation that's gone on in response to those specific policies. None of those policies are complete innovations, but as we'll see, they certainly do take things a big step in a harsher direction. I think litigating in this area is a bit like wrestling with a greased pig. If you lose, the government are likely to say that you shouldn't have brought the case in the first place, and that it was really just a publicity stunt, and the courts have confirmed how fair their policy is. But at the same time, if you win, the government will either pretend that you didn't, or go so far as we'll seek to introduce retrospective legislation invalidating your own court decision. So at the end of the talk, I'll just say a couple of words about whether I think all of this litigation has actually had any useful practical effect at all. I hope so, because that is what I do for a living. So. Okay, looking first at the work programme. We've heard a lot about the work programme this morning. This was a coalition scheme introduced in 2012, requiring claimants on the job seekers allowance and employment support allowance, which is the benefit for people who are too ill to work, for job seekers allowance claimants to take part in unpaid work, and also for both to take part in work-related activity. So that's basically training and support. Now, there's nothing new about conditionality in the welfare system in the UK. Unemployment benefits always carried some conditions to actively look for work. And the Labour government introduced, as we saw this morning, the idea of unpaid work schemes, which was taken from the US example. But the work programme, I think, is an innovation in 3 respects. Firstly, the scale. It's a national programme for outsourcing pretty much all job seekers allowance claimants who've been on benefit for more than 6 months. It includes, second of all, the requirements to undertake unpaid work are much more onerous, with people having to take up to 6 months, in some cases, unpaid work. And then finally, the sanctions regime under the Welfare Reform Act 2012 is much, much harsher. Repeat offenders as so-called camp-based sanctions of up to 2 years. And you have to remember that in the context of all of this, the decision-making around sanctioning has been horrendous. Study after study has shown that the vast majority of people don't really even understand why they've been sanctioned. I mean, if you look at some of the letters that claimants get, it will say, a decision has been made on your entitlement to benefit, you have been sanctioned. Sometimes it doesn't even say that. Please see enclosed. It doesn't even say what it was specifically that you were supposed to have done that you failed to do. And there's only further inquiries that you might find out, or on appeal that you might find out what that is, by which time you've had to live without any benefit, potentially starving or going to a food bank for some weeks. So, how has litigation fared in this regard? Enter Cat Riley and Jamie Wilson, who Cat Riley was required, she was claiming job seekers allowance and volunteering in the museum where she wanted to work. She wanted to work in the museum field. And she was referred to the work programme and required to undertake 2 weeks unpaid work at Poundland, and therefore give up the voluntary work that she was doing at the museum. Jamie Wilson was required to undertake a 6-month mandatory unpaid work placement, which he refused to do, and they both took the government to court for a judicial review. The Court of Appeal declined to find that the work programme breaches Article 4 of the European Convention on Human Rights, which prevents forced labour. They weren't willing to say that unpaid workfare programmes are forced labour. However, they did find, firstly, that the notices that had been sent to the claimants requiring them to participate in the schemes were defective because they failed to inform the claimants sufficiently about what they were going to be expected to do. By that, they didn't say anything at all about what they were going to be expected to do. And more significantly, they found that the regulations that the government had brought in to introduce the work programme were unlawful. They were ultra-virus in the legal sense. They were made outside of the powers granted under Parliament because Parliament had required the regulations to specifically prescribe what the schemes actually were and what people would be required to do under those schemes. And all the regulations did was simply name the schemes so that people could be referred to the private providers. Now that had potentially quite a large effect on the hundreds of thousands of people who were either being sanctioned or had been sanctioned. And the government panicked and introduced emergency regulations and introduced emergency retrospective legislation, the Job Seekers Back to Work Act 2013, to revalidate the regulations and revalidate all of the notices, any defective notice that had been sent under the old schemes. I'll leave it to you to think whether this is surprising, but the bill had cross-party support and was passed within a matter of a month. So they have a piece of primary legislation effectively undoing a decision of the Court of Appeal. And the government's justification for this is they said they weren't willing to allow all those claimants who had sanctions stockpiled in the system and were waiting the outcome of the Riley case to be given an unfair windfall of what the government said would have amounted to £150 million. Fortunately, that wasn't the end of the story because the courts weren't particularly happy about having their decisions overturned in such a way. And so when the government's appeal got to the Supreme Court invented a new ground for finding that the sanctions and the referrals to the work programme were unlawful. They said under common law, there's a requirement to inform claimants sufficiently about the nature of the schemes and the government's policy on whether they should be referred to a particular scheme so that they can make representations about it at the time at which they're referred, trial or a fair hearing before an independent tribunal. And the logic for that being, here you had a lot of claimants who had effectively won their appeals in the system, and now the government had introduced legislation to say that they in fact should have lost their appeals. And so that sort of behaviour wasn't justified in the view of the High Court, which issued a declaration of incompatibility. And then more recently now the upper tribunal, which hears social security appeals, has also weighed in, saying that they don't think the Act really is retrospective at all, applying a very narrow reading, and also that it can be read down so that the claimants, so it can be made compatible with Article 6, so claimants can win their appeals. So both the Riley High Court case and the upper tribunal case are now going to the Court of Appeal to consider again what the court should do about this retrospective piece of legislation. So the verdict on the work programme litigation, you have a very tortuous period, series of cases, but effectively what we have is a standoff between the courts, who are very vigorous in placing procedural protections for the benefit of claimants who are being both referred to carry out unpaid labour and also sanctioned. And the government, on the other hand, which is so adamant and so keen to introduce its policy, harsh policy sanctioning claimants, that it's even willing to disobey a ruling of the court. And we will see, both in the political and legal arena, how that plays out. Next slide. Moving on to the bedroom tax. So I should use the correct terminology for this, is in fact the size criteria for housing benefit in the social rented sector. But it's become a very political issue by its opponents called the bedroom tax, and by the government belatedly invented the name for it as the removal of the spare room subsidy. The context for the bedroom tax is the UK's housing crisis. In the UK, there were traditionally two sectors for housing. The social rented sector is council-provided or housing association housing, where rents are controlled and generally much lower, but it's much harder to obtain that housing. And the private sector, where people are renting from private landlords. And as a result of the right to buy policy in the 80s, a lot of the social rented stock was sold off. That moved a lot more people onto the private rented sector and led to a vast increase in rents. And the burden has been, until recently, taken by housing benefit, which is a benefit intended to meet the cost of housing needs. And the response of both the last government and this government has not really been to deal with the crisis itself by trying to do something about the spiralling rents, but rather to try to reduce entitlement and restrict entitlement to housing benefit for claimants. This was started with the Labour government, which introduced a cap on housing benefit, introduced regional caps and variations to local housing allowance for people in the private rented sector in an attempt to control what the housing benefit for people in the private rented sector, which is obviously very high. And they also introduced the principle of the size criteria for private tenants. So tenants were entitled to a rate based on the number of rooms they should be entitled to. And the regulations set out how many rooms each tenant is entitled to. Briefly, that's a single room for an adult or a couple, and a shared room for 2 children under 10, or 2 children of the same sex, so it's 16. In Berlin, we took the government to court over the size criteria. This is while it was still in the private rented sector, arguing that the size criteria setting out the number of rooms discriminates against people with disabilities. And the two children, one of whom had severe autism and Down syndrome, and because he would have violent episodes, the two children were unable to share a room. And the Court of Appeal said, in quite a landmark judgment, that sometimes, this is applying a European court case called Polimonos versus Greece, sometimes to avoid discrimination against disabled people requires the provision of additional resources. So sometimes even treating people the same, it can be discriminatory. And so the government was under an obligation under the Human Rights Act to provide housing benefit for an additional room for the adult who needed overnight care and the children who couldn't share. So the regulations were changed, and those two groups are now protected under the regulations. But the coalition government extended the size criteria policy into the social rented sector. Now that's much more difficult because for social tenants it's much harder to move because you have a choice really of giving up your council flat and going into the private rented sector where the rent is much higher anyway, or trying to swap. And so the cases in that regard are focused on disability discrimination again in MA and others, and in Rutherford, the case we represented, and cases brought by shared care, where parents both need to care for children, and victims of domestic violence who adapted her house. And those cases have all failed in the courts so far, mainly led by the Court of Appeal in MA, but the appeal is ongoing to the Supreme Court. So to conclude there, we've seen the courts willing to provide for very limited exceptions for severely disabled people, actually requiring the government to pay more benefit. But they're not willing to challenge the policy as a whole. Very reluctant to do so. Finally, the benefit cap. And this is a policy really where the principle behind it seems eminently fair. The principle being that no person should receive more no out-of-work family should receive more in benefit than the average household receives in earnings. So it limits the amount a family can receive in benefits to £500 a week, which seems like quite a large sum, particularly when you look at that as an annual income of £34,000. But behind it lie a series of assumptions and misconceptions that really hide the cruelty of the policy. Principle being, it doesn't compare like with like. Of course, what you're looking at is the average earnings of a household which may have any makeup at all, and a particular household which is likely to have a large number of children, maybe out of work for any number of reasons, most likely to be because it's a lone parent with very young children who has to care, usually a lone mother who has to care for those children, and it also disproportionately affects victims of domestic violence who are fleeing violence with their children and then are made homeless as a result of the cap. A challenge was brought by two such lone mothers, both of whom were fleeing domestic violence and were threatened with homelessness because of the benefit cap. And the Supreme Court, in a judgment just given on Wednesday, gave a very finely split judgment. Two of the judges were very critical and would have found the policy unlawful as it discriminates against women as lone parents and also breaches the government's obligations under the UN Convention on the Rights of the Child to treat the best interests of children as a primary consideration. Two of the judges thought the policy was justifiable, and the third judge thought that the policy breached international law under the UN Convention for the Rights of the Child, but didn't breach UK law under the Human Rights Act, and therefore found the policy unlawful. But his parting words were that it is in the political, not the legal arena, that these decisions will have to be made. So to summarise, what has all this litigation actually achieved? And it may be seen on a harsh view that not very much, because the three main policies that I've outlined are intact. Both main political parties are talking about lowering the benefit cap. solutions to these problems. And there have been significant small victories for small groups of people, for example, groups claimants on JSA or the Burnett disability exception. And also, these cases have created a great deal of campaigning force. The benefit tax is a very unpopular policy, partly because the disability cases have raised the profile of the harsh effects of that policy. And finally, when we go on to the next stage of welfare reform, certainly having had a very fine, close judgment from the Supreme Court, any new government is going to have to think twice about introducing even harsher policies. But perhaps the Supreme Court judge Will Conway was right in saying that essentially these issues are going to have to be settled in the political and not the legal arena.